The Center for Educational Media and the College of Education at Middle Tennessee State University are proud to offer professional development to K-12 educators in Tennessee through our online video library. These videos are aligned with standards set by the Tennessee Department of Education. For more professional development videos, check out our website at cem.mtsu.edu.
Okay, so we're going to get the day going, and one of the key partners in every one of our collaboratives is the Tennessee Department of Education, and they generously, graciously present at every conference we have. And so we so appreciate that. Dr. April Ebinger is one of our regular presenters, and she is a supporter of the SPED Collaborative and has been for several years now. So I'm happy to welcome her for our first session this morning. So Dr. Ebinger, glad you're here.
Thank you, Dr. Clark. Welcome, welcome, good morning. I'm not going to try to jazz you up or quiz you about what time you got up, because I probably was the last one to get out of bed this morning. So, I'm so excited that you're here this morning. How many of you are special education teachers? Principals? District admin? Related service providers? General education teachers? I love that there's some general education teachers here. This is awesome. Anybody that I missed? All right, I'm April Ebinger. I'm the Director of Psychological and Behavioral Services for the Tennessee Department of Ed. I live in the Special Education Department, but I oversee all things around evaluation, eligibility for both IDA and Section 504. I do all of our behavioral supports for students with disabilities, and then I oversee 2 of our school-based mental health grants, Project RAISE and Project Inspire. So if you don't know what any of that is, or if you ever have questions, please reach out. That's why we're here. A lot of people think that we are, at the department, we're untouchable, nobody can contact us. I hope that you don't feel that way. My job is to serve you so you can turn around and serve our students, okay? So I'm gonna jump right in. This is our top 10 list around how to prevent dispute resolution related to reevaluations. And these are from actual administrative complaints, mediations, due processes across the state over the last few years. I know a lot of you as special education teachers, you may not feel like you're part of reevaluations, but you are. Everybody on that IEP team should be included when a reevaluation is occurring, and your role is just as critical. But I will say, as we're talking about these top 10 ways to prevent dispute resolution, if you see something, I always kind of joke, if you see something, say something. If you're thinking, hey, that big tall lady told me that is a red flag, tell your team, right? We know that dispute resolution across the state has increased over 100% in the last 2 years. And so I was out at a district this past week, and they said, April, what can we do if a parent threatens dispute resolution? What can we do? A lot of times there's nothing you can do by that point, right? What you can do often, reach out to me. Sometimes the parents just need to hear it from somebody that's not you. And I love, and it's my privilege to educate parents when sometimes they're wrong on their interpretation of the law, okay? So you could start there, but oftentimes dispute resolution may be inevitable, right? But I am very proud to say on behalf of school districts, so we had around 165 administrative complaints last year. The previous year, we were just over 100. We're seeing this twofold increase almost every single year. More than 50% had no findings or fell in the favor of LEAs. What does that tell me? That parents may be upset about decisions that are happening, but you're doing the right decisions that are what's right for the kid, and you're providing FAPE. You're following your procedures, okay? Now, there's gonna be times that parents file an administrative complaint or they file due process, and there's gonna be something that they catch, right? It's okay, it's okay. It's a good learning opportunity for you and your district to improve and ensure that those practices, those procedures are followed. Okay, this is our agenda. We're gonna pop right in. We know that state and federal law essentially require us to ensure that every single child is afforded an initial evaluation and those subsequent triennial reevaluations before a child is provided services. And then every 3 years, at least every 3 years, we're going to reevaluate. We're going to talk about that in just a second. We know that anybody on the team, even my general education teachers, can initiate a reevaluation. Here's what we see often around dispute resolution. As our students with disabilities, there's a time when the IEPs start to look the same. Every single year, the IEP, the goals, the services are the same. If that's not a red flag for you, somebody should be asking questions. Because here's what our parents and our advocates do. They come and they bring last year's IEP and your proposed IEP and they set them side by side. If nothing has changed procedurally, you're out of compliance, okay? Something has to have changed. And if you say, April, the child didn't meet their goals, that's okay. Is that okay? Absolutely. What are we going to do to ensure that that next IEP is reasonably and appropriately calculated? Meaning that maybe we need to collect some more data through a reevaluation. Maybe we were too ambitious in our goals. What do we need to do differently? Because if we still have that same IEP, that's going to be a problem procedurally, because how can you argue then, and this is what we see a lot at the State Department, especially when we have angry parents who call us, folks, if the child is not making progress, don't tell us on that progress report that they are. We were looking at a recent parent complaint that came in. Every single progress report said they were on track to meet their goal. But every single narrative and all the data that you provided or that district provided said they weren't even close to meeting the goal. So let me give you like a generalized example that's not specifically for this case. Let's say that they were working on letter sounds and the goal was to have 80% of 26 letter sounds, whatever, right? The narrative in the note said that the child was able to do 1 or 2 letter sounds throughout that monitoring period, but they had marked they're going to meet the goal by the end of the IEP. The end of the IEP was 3 weeks away. Is that a problem? Do you think that the administrative complaint prevailed in the side of the district? No. Give us the honest information. If the child's not making progress, it's not necessarily that you're doing something wrong, but you got to notate that accurately. Okay? And then if necessary, initiate that reevaluation. Okay, what are required during reevaluations? This is what's listed in federal law. If you've ever seen our TM Pulse system, you're gonna notice that we have built out the components of this. I'm gonna get to the slide that I wanna get to here. You have noticed the components of this. If you complete all of these tiles, you're meeting state and federal law, okay? So this is our reevaluation section. It's asking for input from our general education teachers. It's asking for input from our special education teachers, our related service providers. All of you are critical members of the IEP team. It's not just me as the school psychologist, you as the special education teacher, or the LEAs. All of us combined are vital and important to ensure that students are making progress. How many of you saw our recent TCAP data that came out? A lot of the Tennessee Department of Education was very celebratory. We had a lot of historic gains across the state. The one sub-area where we're not showing gains is where? Our students with disabilities. And as somebody who was a general education teacher before I got into the world of psychology, I know as somebody who taught all of our students with disabilities in my grade level, it's difficult, right, to individualize and ensure that they're getting what they need. But oftentimes what we do is we don't have the right data that's driving our decisions, and it's a one-size-fits-all approach for every single student with a disability. One of my biggest pet peeves at the department is I look at a child's IEP, every single kid gets the exact same. Every single kid gets 5 days a week of 45 minutes of intervention. Every single kid gets 3 times a week of speech language for 30 minutes. That is not the spirit of IDEA. It should be individualized based on what they need. Some kids may need 2 days a week. Some kids may need 3 days a week. Some kids may need 5. But how are we individualizing that to ensure that they're making progress? Okay? Let's jump right in. All sections must be completed. That seems like a duh, right? You would not be surprised how many administrative complaints that we get because a section is not complete. Make sure that all of those components are there. One, because if we don't have the data to drive the decisions, What data are we using? Oftentimes, how many of you have been sitting in an IEP meeting, you're probably not leading, or excuse me, a reevaluation meeting, you're not leading this, and the speech language pathologist or the school psychologist says, we're just going to do this by file review. It drives me bonkers. Because I, as the psychologist, and I go out and I look at these files from across the state, we have so many kids who were evaluated one time ever. They were evaluated when they were 3, when they were going through their TIS transition. And we were like, oh, this is valid data. And now they're juniors in high school, and we've never reevaluated them formally. We file reviewed them, haven't we? You, as members of the IEP team, have a duty, and you should be asking those hard questions. When was the last time this child had formal evaluation? It doesn't mean we have to do a full comprehensive, full psychological on the kid. Maybe if they have autism, we're doing some adaptive, some social emotional measures to help drive your goals. Folks, as special education teachers, the reevaluation protects you. It ensures that if you have current and valid data, your goals and your services are appropriately calculated. And now you're not fishing for what would work for this kid. You actually have some standardized data behind you as you're making these decisions. Ask those hard questions. If you have a kid that's been file reviewed more than once, that's a problem. For me, that's a problem. And most case law is going to tell you that if we're just rolling kids over because we know they still have autism, we may know that they still have autism, but what do we know about that adverse educational impact? What do we know about their services, supplementary aids and services, and those accommodations, modifications? How do we know that those are right? We should be reevaluating more often. Okay? We know we need observational data, as I mentioned before. That means we need general education teacher input, special education teacher input, related service providers, and we need parents. Parents are required federal participants in the IDA process. Parents don't just get to sit out and say, I'm done, I don't need to participate anymore. IDA actually carves out that parents are entitled to meaningful parental participation. Meaningful. We saw a due process this year in the Sixth Circuit, not in Tennessee, but in the Sixth Circuit, where every time a parent brought up a concern, the IEP team said, we're not talking about that today. Do you think that's okay? No. It doesn't mean you have to have time. Guys, I know that a lot of times your IEP meetings, if we took a poll of your longest IEP meeting, that would be fun, right? You can set parameters for your IEP meetings, especially if you have multiple. We don't want to pull you from services with kids, but if a parent says, I have a concern, I have a recommendation, we have to give space and time for that. It doesn't have to be at this meeting, but it needs to be at something soon. And then you're going to document in your prior written notice that the parent brought it up. You're going to schedule another meeting to hear those concerns or those recommendations, okay? Scenario. Connor's IEP team is meeting for his triennial reevaluation in 4 days. The case manager notices that the parent observation form has not been returned. What would you do? Would you ask the special education teacher to complete the questionnaire? Call the parent to inquire, interview the parent over the phone, just ignore the form because she never comes to the meetings anyway. Call the parent. See if you can get her to complete it, orally. Nothing requires that the parent signs the form. Technically, under federal law, there are 3, with state law, there's 4. There are 3 circumstances in which a parent must sign a document. Let's do a pop quiz, special education teachers. What are those 3 federal forms that they must sign? Anybody want to give a guess? Initial consent. They must sign initial consent. What else must they sign? Not manifestation. That was a good guess. Nope. Everybody thinks so, right? First IEP. Initial provision of services. Initial consent, first IEP. Okay? If parents sign neither of those, you're not moving forward at all, right? You're done. Dead in the water, right? The third one are reevaluations. How many of you have moved forward without a parent signature on a reevaluation? We'll talk about that in just a second. Now, state law extends this just a bit. Parent signatures are required on FBA BIPs. Okay? FBA BIPs in the state. So go back to that eligibility though. Eligibility must be determined by whom based on federal law? Parent and a qualified group of professionals. So it would imply that the parent is there making the decisions, but a signature technically is not required, okay? All right, we're gonna call the parent. We're not just gonna say, oh, well, they're not gonna get it in. One, procedurally it's a problem, because this is what we know. And I'm not saying this is every parent, but let's say you get to your reevaluation meeting and the parent does show up, but they never completed the input form, and then they don't like the outcome of that meeting, and then they file in a complaint and they say, I didn't have meaningful participation. What documentation now do you have that they did provide meaningful documentation? Just their presence alone does not constitute meaningful participation. Even if you don't have this form for the reevaluation, what level of input do you have? So let's say you're coming to your annual IEP meeting. Do you have a parent input form? Or we have our parent input section. That's sufficient as well. But how are we documenting our parent input, okay? And how are we hearing what they're saying and using that information to move forward? And I'm gonna say this too, the A up here, never, you're never signing anything for parents. I can't tell you how many times I'm looking at files and the parent is on the phone, which is fine. Parents can attend by phone, right? Any level of IEP reeval meeting. And they say, just sign for me. Please don't ever do that. We are not proxies for the parent. We don't sign on their behalf. What can we do? We can notate that they participated by phone. And if you need a signature for any of those 3-4 documents we just talked about, we can send those home. Okay, but don't sign for parents. That was something that came up. It didn't come up in an administrative complaint, but it did come up in a due process where a parent alleged that they were never given access to come to some of their meetings. They were given access to come to their meetings. The school district did a great job of showing all their invitations, all of this attempts to engage the parent, but the parent would often punt it to the district and they would sign on their behalf. Don't do that, don't do that. Okay, we know formative and summative assessments are required. This is one area where I think a lot of folks in that reevaluation, they're not quite sure what to put in there, especially for our younger students. I'm gonna skip over this because you guys know, you're the experts on formative and you know what summative assessments are. I wanna get to my list real quick. Again, we know that the purposes there are of classroom connection. All of our students with disabilities, I don't care from a student who has a mild specific learning disability all the way up to the most significant cognitive disability, should be working on grade level standards. And that's why we ask for formative and summative for every single student. Now, if you ever said, April, I don't know what to put in that box, we don't progress monitor this student. And if I have to hear about progress monitoring one more time, that is one measure. My general education teachers, how many assessments do you do all week gauging student learning? That's such rich information that oftentimes in the special education world we say, well, that's not what we need this. We need all of that, right? It could be anything formatively happening in the classroom that we're using to input into that reeval summary to gauge their progress towards grade level standards, their adverse impact of that disability, and how they're attaining those IEP goals. Anything really can be summative as well. I actually have more exhaustive list here. If you email me, I can send those to you. But just know any of these things can be included. Now you'll notice we have some neither categories here. Let me go back here because I did not know there was only 3. We're not going to be putting standardized assessment data into the formative and summative sections, but we certainly are going to include anything that our team needs to make some meaningful decisions for students with disabilities. Now I already alluded to this, file review versus assessment. Whoever named the reevaluation summary review, the RSR, I wasn't at the state when they did that because I probably would have said, hey, that's a problem because it's a misnomer. When you complete, how many of you have ever completed the RSR packet for your team? Has anybody ever done that in the room? A couple people? When you bring that to the meeting and it says reevaluation summary review, It's not a reevaluation. It's a file review to determine if your student needs a reevaluation. And so because it's called reevaluation summary review, I hate that they even included the word reevaluation. I wish they would have just said summary review or file review, because people think that that constitutes the reevaluation. It doesn't. It's a file review. So you remember how I told you we're just doing file reviews and rolling them? So we could potentially get to a meeting for a student with a disability, and we could review maybe their past standardized assessments and a couple formative pieces of data that the teachers have collected and a couple pieces of summative data, and that alone is what's driving continued eligibility and their IEP. Problem. We have to have current and valid data to help understand the student's current strengths and weaknesses in order to truly drive that IEP plan. Okay? All right. To test or not to test, I love that, right? We know that a file review is required as part of that. You don't need consent for the file review. So let's say mom says, I'm not coming to that reevaluation. Now, I just told you that you need a parent signature on a reevaluation, right? The file review is not a reevaluation. But let's say during that file review, your team says, yes, we want more data. Does that require a signature? Yes, unless we get to a couple different exceptions, which we'll talk about here in a second, okay? File review cautions. Remember, almost every time this has been brought before the courts, districts have failed if they're not collecting updated data. Now, I say this as a seasoned psychologist. Folks, I had a high caseload, and if you told me I had to do a comprehensive eval on every single reeval, I would have probably cried, right? But I would always rather, and I always think, what is most legally defensible? I would rather have something, if I was subpoenaed onto that court, to say, I did this, I didn't do all of this, I did this to help justify that. Again, whether it's 1 rating scale, maybe it's a direct observation. What are we doing to drive those services? And certainly, if we have students on alt assessment, if we're using 1 cognitive assessment ever to drive alternate assessment, whew, if that was your child, your sister, your brother, we all know the complexities and the long-term historical issues around cognitive assessments, and we give a child at 3 years old a cognitive assessment, and then when they're in the 2nd grade, we say, oh, you're eligible for alt assessment of how you performed when you were 3. Come on now. Please don't do that. Updated evaluation, and do it through your RSR process if you need to. Okay. We already know what that is. Okay. Oh, the big part here, let me go back here. How many times have you been sitting in a meeting, and I'm not trying, there's no principals here, right? You're not going to tell me now that I said that, right? How many times have we been sitting in a meeting and a parent says, well, they've been diagnosed with disruptive mood dysregulation disorder. Do you know about that disability, the new one that came out? DMDD. And the principal or somebody said, well, you need to go out and get an outside diagnosis before we'll consider it. Have you heard that before? Is that a problem? Anything that we require of the parent has to be at no cost to them. And so if we ever tell a parent, you need to do this, or you need to bring us this, it should be at no cost to the parent. Procedurally, if you tell them you need this diagnosis, you need to get your kid tested for autism, you need to get them tested for ADHD, it should be at no cost to parents. And if you at all say that it is at their own cost and you can't, and you're requiring them to do something before you'll trigger child fine, anything, procedurally you're out of compliance, okay? So anything that you require of them should be at no cost to them. When we're thinking about questions, SPED teachers, case managers, when was the last time they were evaluated? Are there new concerns? Are there old concerns? Are we making progress? All the things that we talked about. And if you're saying this IEP is the exact same, we're not able to change the goals, we're not able to change the services, we're not able to start to wean them back from this level of support, that should be sending red flags up for you that you need to do something, and that could be a reevaluation, okay? Okay, We're going to skip through all this. This is all procedurally what you choose. I don't care what you choose. If you're going to do a full comprehensive evaluation to change eligibilities, do that. How long have you guys been in Tennessee working? I say this because I have worked in different states, and Tennessee is kind of a unique state where we have primary and secondary eligibility categories, and now we added that tertiary. Has anybody worked in another state where they don't do that? There's other states that are non-categorical. You're either eligible or you're not. They don't even assign a label to you. And then there's other states where you just get one. I'm of the camp that I wish we just had one, right? And let me tell you why. IDA says you're either eligible or you're not. And how often are you in meetings where parents are quibbling over which eligibility categories are going to be tacked on? Well, they're primary SLD, but I want language and I want speech and I want OHI tacked on to that. It creates a problem, as opposed to if you just had to choose one, they can still get all those other related services, can't they? They can still get language and speech, OT, PT, counseling. They can get all that under SLD. But if you only could choose one, which one would that be? Because IDA says you're either eligible or you're not, and they don't concern themselves with labels. We do. And there's so many times I have an email in my inbox that I've tried to ignore it, where the child is SLD, OHI, LI, and the parent wants the team to evaluate for autism. Huh? So now we're going to have 4 categories for this kid? How confusing is that? And I know we have some general education teachers here who may not have backgrounds in special education. You show up with that accommodations at a glance, and they say specific learning disability, OHI, other health impaired, likely for ADHD, language impaired, and then autism. How intimidating would that be for your teachers? Holy moly. More is not always better in special education, folks. And so in this case, though, we need to know, are we changing the primary, and then we need to select the right option on our RSR form, but we have a lot of options where you could just test for programming purposes, okay? We know, as I mentioned before, parental consent is required for a reevaluation if you're gonna conduct some more assessment. So if you're not able to get that, how many times, I've had so many parents who don't show up for reevaluation meetings all the time. What can we do? Are you kind of stuck or paralyzed if they don't show up? So if a parent doesn't show up for a reevaluation meeting and you've given them reasonable attempts in special education, what's reasonable for us? I heard somebody say it. 3. Where do we get 3 from? Does anybody know? I always ask that question because most people are like, I don't know, April, who made that up? Who at the State Department said 3 was reasonable? 3 comes from IDA. IDA says that if you're trying to make contact with parents, you're going to do so through phone calls, electronic means, or home visits. 3. So reasonable attempts for us is, have you called? Have you emailed or texted? And have you tried to do a home visit? And home visits, folks, it doesn't have to be like truly going to their home. Have you tried to meet them at the car rider line? Have you tried to connect and say, hey, where's your mama working over this weekend? And she's, working at the Piggly Wiggly and going down to the Piggly Wiggly, right? What have we attempted to do that's reasonable? That's where we get the 3. So if we made 3 reasonable attempts to engage parents in the re-eval process and we cannot get them in, we can move forward with the evaluation even without parental signature, okay? Now let me tell you this. We had a really interesting, actually I think we've had 3 administrative complaints this past year. So let's say you get to your re-evaluation and a child was developmental delay. And I want you to tell me if you had this because it's coming up all over the state. Child was developmental delay, they're aging out. So we know that students can only stay as developmental delay until 9 years, 11 months, so right before they're 10. We have to do a comprehensive reevaluation, right? Because they can't stay DD any longer, they're gonna age out. And the parents say, you're not doing a cognitive assessment on my kid. Has anybody had that yet? Oh, you're lucky. I don't want you to do a cognitive assessment because maybe the child has Down syndrome and they don't like the ID label. What do? Have you had that? There is such thing as partial consent. This is not a buffet where parents can come in and say, I want this assessment, I don't want this one. They either accept that provision of the evaluation or FAPE, or they accept none of it. So let's talk about what that means. One, this has been tested in our administrative complaint process now, I said 3 times. We had 3 different parents across the state who they were the exact same scenario. Actually, that's not true. 2 were developmental delay that needed to be reevaluated for potential ID who had Down syndrome. Our Down syndrome community in the state is taking a very strong stance against cognitive assessments. Unfortunately, they're just misguided, right? Cognitive assessments alone do not mean that the child's going to be in the most restrictive placement, that they're no longer eligible for a regular ed diploma, any of those things. The third one was interesting because it was an out-of-state transfer, and the child had multiple disabilities, but as we talked about how other states do things differently, they didn't use cognitive assessments. In fact, the state they were coming from outlawed cognitive assessments. So the parent had never had to experience cognitive assessments, and so when the team says, we need to administer this eval, the parent said, absolutely not, you're not doing that. There is no such thing as partial consent. Let me give you another example that happened this summer. This actually was for an initial consent, so I'll step out of the reeval realm. The parent signed initial consent, and they signed initial consent in May. The parents were informed, hey, we're not going to be able to finish this eval in the 60 calendar days, and we're going to have the child come into our summer programming to finish the eval. And the parent said, no, because I want the gifted teacher who was not working over the summer to be a part of the initial eval, and I want the child to sit in the room with the SRO. So the district called me and they said, April, I need a timeline extension. And I said, absolutely not. Parents don't get to dictate your timeline. You have 60 calendar days pursuant to federal law. They don't get to modify that, right? And so as I was, kind of asking questions and querying about why they were delaying this, the parents were not being reasonable. Once they make demands on the consent is null and void. All right? And I'll also say this. If a parent comes to you and says, I want whoever to sit in the room while I've had parents ask for their advocates to sit in the room. They've asked if they could sit in the room. Is that okay? Would we allow a parent to sit in the room when they're being administered the TCAP? No. We must follow our standardization processes, and there's only a handful of assessments that most of our assessment specialists are trained on where the parents are required to be in the room, especially for autism where we need them to, call out their name to see if they'll orient and respond. But most assessments, you automatically invalidate them if anybody else is in that room. That's your argument, isn't it? Not just because I don't want you in the room, I don't want you to steal the test questions, or I just don't like you that much and so I'm not going to play ball with you. No, most of our assessments cannot have anybody else in the room, and that's the argument. But as soon as parents put conditions on the eval, and by the way, the district revoked consent, and this parent called me super upset, and I supported the LEA. I said, absolutely, they're entitled to do that. Because if not, so let's say that the school district was like, okay, then we'll just wait till August. And they exceeded the timeline. What can the parent do now? She can file an administrative complaint against the district that they failed to fulfill their child find duties. And guess what? The district would be on the hook for comp ed services. Follow your procedures. And then reach out if you have some of these oddball ones, okay? Let me say something about informed parental consent, because this is not just about reevaluations. Are we truly informing parents of, one, what we're doing and why, and what we suspect? Think too about your IEPs. Are we fully informing them? How many times have you gotten to, especially my secondary SPED teachers in the room, a parent was like, I didn't know I signed for alternate assessment when they were, 8. I didn't know what that meant. Having transparent conversations will absolutely ensure that there's clear communication. One, you're going to document clearly in your prior written notice what you're going to give parents, but are we ensuring that they understand what we're giving them? And there's going to be times where, we speak in a lot of acronyms and legalese, but we need to ensure that parents are fully informed. I've had so many parents come back and say, April, I didn't know they were evaluating for ID. And there's no evidence that they ever told the parents they were. They started the eval and put in their prior written notice that they suspected specific learning disability, and then for some reason, in the middle of the evaluation process, they switched it over to ID. The parents were never informed. Is that a problem? Yes. Please don't surprise parents, especially with something that heavy, added eligibility meeting, if you haven't informed them, because it's a procedural violation, okay? This is a complaint from District of Columbia. It's so interesting, a lot of our case law that we use comes out of DC for some reason. Contended that the LEA did not review, did I miss the, no I didn't. Did not review all existing data or evaluate in all areas of suspected disability. The evaluate in all areas of suspected disability is so important, folks. Complaint from District of Columbia contended that they did not evaluate all areas of suspected disability. This is the hot one. A lot of parents like to say, they like to come back and say, well, you didn't evaluate for written expression, or you didn't include an OT eval, right? Folks, this is why it's important on the front end to get all of the input and all the data, because sometimes our general education teachers see things that we don't see during our special education sessions. What supports do they need, and do we need to evaluate in the areas that we suspect? Because if you don't evaluate in all areas of suspected disability, even if they're not tied to that eligibility category, okay, we're at fault. The finding here, I know this was a really simplified version, said that the LEA reviewed progress reports, teacher observations, classroom assessments to document the student's disability. The documentation helped show that the district reviewed appropriate data and documented the needs of the student. In this case, they essentially looked at the file review data, and that is sufficient to help determine whether to continue a disability or not, all right? And that's sufficient, but it doesn't mean that necessarily we've evaluated in all areas of suspected disability. Timelines. Let me give you an administrative complaint that happened this year. So teams signed consent for the reevaluation in August. Okay, they came back from school, signed the reevaluation. They did not meet to review those data and modify eligibility until April. Parent filed administrative complaint. How do you think our Office of General Counsel ruled? Parent or LEA? Parent. That's not reasonable. There are no timelines under IDA or state law for reevaluations. You just must do it before the deadline, right? But if you sign consent for an early reevaluation, you must do it within a reasonable time frame. Now, we say 60 calendar days is reasonable. Is 61 reasonable? Yep. Is 62 reasonable? Probably. The further I get from 60, though, the less reasonable it gets. So whatever that timeline was, the 200 and some days that had passed from August to April, that's not reasonable. Now here's the kicker of this, folks. If you were reevaluating to suspect a new disability and new services that could have potentially come with that, and you dragged your feet, now what are you on the hook for potentially? Comp ed. Be cautious. Work within your timelines. Now I'm also going to say this. I know a lot of our districts are experiencing shortages, right? You may not have a school psychologist, a speech-language pathologist, but if you sign consent, your district's got to get somebody in there to do it. You can't just sit on it and say that it's a staffing issue. Federal law doesn't jive with that. Special ed is very different than a lot of our other fields, because in a general education classroom, by and large, we can make do with a substitute, can't we? We can't do that in special ed land. You guys are very valuable to your districts. So especially our school psychologists, our speech-language pathologists, our OTs, PTs, we have to have those professionals in our school buildings, and there is no exception, there's no waiver for those, okay? We already talked about that. Let's look at this case study. An Ohio charter school began the reevaluation process within the triennial timeframe, but due to delays in obtaining, this is a critical part, obtaining informed parental consent and documentation issues, they did not complete the reevaluation until 2 years post the date of the reevaluation cycle. Did the courts find that this was an issue? Yeah, absolutely. Now here's the thing. Let's say you get to your reevaluation, and in this case, the parent refuses to sign it. It's not that you can't find them, like I told you before. What I told you before, the reasonable efforts, you can't find the parent. This is the parent says, no, you're not doing that. What are your options? The only option you have is to file due process against the parent. Okay? Now, a lot of our districts probably won't do that, so you could, because you already know that you don't need a signature for a file review, you can keep them eligible, but what if they're developmentally delayed and you got to get them off that category? You must file due process. Here's the other piece of this. If you say you're not going to keep them eligible under file review, you are not going to file due process, because we all know that's an expensive process. Because the parent refuses consent, what did I say before? There's no partial consent. As soon as the parent refuses to sign anything, they are no longer eligible. Okay? No longer eligible. This is all guidance that we've had in the last few years, especially given a lot of how many of you guys have had some really gnarly advocates come to your meetings? There's a few in the state that, if I ever saw them in a dark alley, don't repeat that to my boss. Now that it's recorded on this website, I probably should have said that, huh? However, I find a lot of really great advocates do a lot of good in our meetings. They help educate the parents, they help advocate for services and increase the parents' knowledge of the process. But we also have a lot of adversarial advocates who come in and they're just looking for a fight. And they like to pit you against the parent. They decimate the relationship and the collaboration between you and the parent. There's accusations, there's threats. That's not what's best for the student. That's not what's best for the student at all. And if we always keep ourselves student focused, I think we all win, always. So again, if you ever encounter any of those adversarial advocates, please reach out to me. It is my privilege and my honor to help you combat a lot of what's happening. So yes, in this case, absolutely. Even though the parent dragged their feet and kept saying, no, no, no. How many of you have never finalized an IEP because the parent keeps saying, but I want to table this for our next meeting, and our next meeting, and our next meeting, and our next meeting. And then 6 months goes by, and your IEP is so out of date because the parent keeps calling new meetings and refuses to allow you to finalize it. Stop the hamster wheel of madness. Okay? Because again, your IEP is out of compliance. Do parents have a procedural claim against you? They do, and it's their fault, but it's a procedural violation. If that ever occurs, reach out to us. We'll help walk you through it, okay? Sufficiently comprehensive. I talked to you about this before. This citation from federal law is so vital for you. Evaluation is sufficiently comprehensive to identify all of the child's special education related service needs, whether or not commonly linked to their category in which they've been identified. Let me give you like a really broad example, okay? Child with gifted. Are you guys familiar with gifted standards? So we do a cognitive, we do achievement, and we do characteristics of creativity or giftedness, right? Those are the 3 required components. We've had some claims, though, in the state that said, you should do some social emotional evaluation, because my kid with gifted, he has a huge perfectionist side, and if it's not exactly right, he refuses to move forward. And should that be addressed in the IEP? Maybe. My kid with gifted also has some struggle with interpersonal relationships because he's so, bless you, so smart that he struggles with building good relationships with kids at the same age. And oftentimes the kid thinks he's being mean and rude. Is that something we could address in an IEP? Yeah. We also have kids that have some comorbidities for giftedness around anxiety and depression because they know they're different. But I just told you that the 3 criteria for gifted eval to qualify them is cognitive, achievement, and characteristics of giftedness, which is a checklist, right? Are we evaluating in all areas of suspected disability? This is why teachers, gen ed teachers, special ed teachers, when you're sitting in those meetings, this is what he presents it as. This is how it looks like in my classroom. If he is having to be timed and he can't do it perfectly, he shuts down. This is why we need your input and to ensure that we can evaluate in all areas of suspected disability, okay? And this could go for any category. Remember, just because the child is OHI for ADHD doesn't mean he can't get language services, speech services, any of those related services. We serve students, not categories, okay? I hear that a lot from parents. They'll reach out and say, well, my kid has autism and they say he has to have this in order to get this service. That's not how IDA reads. As soon as they're eligible, the gates of special education open, and whatever you as the team decide is most appropriate to receive FAPE, that free and appropriate public education, in their least restrictive environment is what they must get, okay? All right, prior written notice. How many of you love a prior written notice? Most people hate it. I see like one hand, and she didn't even want to raise it very high. She did this. Most people hate prior written notices because it's just another, I got to check this off, I got to write this document. Anytime something happens in a dispute resolution process, the first place they go to is what? Prior written notice. This prior written notice will either help you or hurt you in that process. How many of you as case managers, are you the ones who write the prior written notices? Usually? I've heard from some districts that the principals write it. I'm like, well, that's kind of cool. I've heard the assessment specialists sometimes write it. I've never heard that the general education teachers write it, but usually it falls back to the case managers, right? The critical piece here through the prior written notice, though, especially when we're talking about reevaluation. How many of you conduct your reevaluations and your annual IEP meetings together? Are you allowed to do that? Yeah. Absolutely. IDEA even says, to the greatest extent possible, consolidate meetings on behalf of the parents. So if you could do a reeval and an annual IEP together, that's fantastic. But let's say you decided to do a reevaluation, to conduct some more assessment in that meeting, and you still went forward with your IEP. What should you do, which is best practice once you're done with that eval? Come back together to review it and update the IEP as necessary. Absolutely, procedurally, that just puts everything in a tight little nice bow on that present. But we need to indicate what we're doing. So often in our prior written notices, we forget the meat of the meeting and we talk about the steps. We're having a reevaluation, we're proposing a reevaluation. Number 2, it says, because it's required under federal law. If a judge picked that up, he wouldn't have a clue what happened in that meeting. In your reevaluation means what are you proposing or refusing? You're proposing a triennial reevaluation to determine if Johnny continues to be eligible as a child with specific learning disability and reading fluency and math computation, whatever. That's the proposal, aren't you? Tell us what you're doing. Tell us what you're considering. Give us that meat of what's happening in the meetings. So if parents come back and say, well, I didn't know we were considering adding this eligibility category, now you've documented that the team is proposing a comprehensive reevaluation because the child has specific learning disability in basic reading, but now we suspect other health impairment for ADHD. Now you've given us that story, okay? It allows parents to understand what the scope of that meeting was, and it certainly protects you as you're moving through that process. These are just some statements here that you can absolutely use. Case managers, you probably recognize these statements because these are the exact same statements that live in our TM Pulse decision-making kind of logic model. Use those statements. Copy and paste them and individualize them to say, Johnny an evaluation is needed to determine if Johnny still has an existence of a disability. Just use those statements. and tell us what those disabilities are. Be cautious about using acronyms in your prior written notice. So many times we've seen due process orders that will come back, and you'll see where the administrative law judge or their accompanying attorneys at the bottom in their footnotes have to define out every acronym that we use. And oftentimes I don't even recognize, truly, I don't even recognize our acronyms. I just had to do a deposition for a due process against the department. And so as I'm testifying on my deposition, I'm just throwing out acronyms. And finally the plaintiff's counsel said, "What is an MDR?" Oh, oops. We assume that everybody understands our acronyms. We assume our general education teachers understand our acronyms. Make sure that we're writing those out in our prior written notices. Here are a couple examples that we provide. These concerns can be associated with multiple disability areas, so we request permission to evaluate in these assessment areas that align with autism, language impairment, other health impairment. Tell the parents what you suspect. Don't surprise them. These concerns are currently being addressed through the current programming based on a review of existing data. All the data that you consider, no assessments, additional assessments are needed for continued eligibility under intellectual disability. That's a perfect statement for any area that you're considering just rolling and doing a file review. You've considered all these pieces of information, and now you all agree that you're just going to keep the student eligible under those categories. Okay, let's do this one and let's talk a little bit more about exiting from a disability. It doesn't happen often, but we see a lot of errors around exiting students with disabilities. An IEP team in Ohio exited a student made eligible under the category of autism from all special education related services. The team did so on the basis that the student was working independently in general education classroom and determined that a 504 plan would better meet the student's needs. Talk to me. What do we think? Okay, I hear not enough data to back up that assumption. What else? They still have a disability that may need to be addressed.
There may be something different, but it still may be due to the disability, they still may have some other issues.
They still may have some other issues. Absolutely, go ahead, say it again.
They would need to, the child still has a disability.
Right.
They still have autism. And even though they may be able to do the work independently, what other issues have shown up because as children grow older and they get into middle school, other things manifest.
Absolutely.
Due to the disabilities, and they still may need that support.
Yeah, working independently is a great goal, right? But my general education teachers in this classroom, how much do we have to do to get them to work independently? How many prompts do we have to give them before they would work independently? How many checks for understanding do we have to do? How many walks arounds? This is a very simplified version of what could be going on in that classroom, and we need to be asking better questions. Meeting that goal is fantastic, but what other needs do they have? I always like to liken this to speech language because oftentimes I'll be in meetings and like, oh, they mastered that sound. That's fantastic that they mastered that sound. Are there other errors that they could have now? Or they really improved their expressive language, their ability to communicate their wants and needs. Do we know if they have any other expressive or receptive concerns that we need to address? We can't know that unless we evaluate in some sense of the word, right? So let's see what the court said here. The Ohio Department of Education essentially found that the LEA did not conduct a thorough review of existing data. They did not conduct observations. They did not get any parent input before they exited this child. They did not consider if new assessments were needed. They did not look at outside reports. And then they completed a flawed prior written notice. That is probably my favorite part of this because essentially the courts came back and said, you have no justification why you terminated this child's eligibility outside of just being able to work independently. So be cautious of that. We need to have multiple pieces of data. If we're going to exit a child with a disability, IDA requires that they're evaluated before their eligibility is terminated. Now let me give you a little bit of nuance here. I just told you we have primary, secondary, tertiary, right? So let's say we're going to exit them from a tertiary. Do we have to do a formal eval for that? No, because they're either eligible or they're not. And so these secondary, tertiary areas, you can drop those at a reevaluation. It would certainly be my recommendation, though, that you're having some level of data to propose to your team to drop them from services. But if you're going to terminate eligibility in totality, meaning that they're all going away, you must evaluate. IDA says it, okay? So you need to ensure that you're evaluating and you're looking at all those areas that she mentioned, especially as the child's getting older, as more independence is coming, as more demands are placed on kids. Are we ensuring that they're left to success? Let me say one thing about that case from Ohio. Have you guys ever been in a meeting, an IEP meeting, and they were like, oh, the child can be served under a 504 plan? You're not the 504 team. They're separate processes. So if you're sitting in a meeting and you're terminating eligibility for a student under IDA, you have no authority, special education teacher, staff, to say that they would even qualify under a 504. They probably would, but they must be evaluated first, and the 504 process must play out, okay? So be cautious of saying, oh, they can get a 504. Okay. Before exiting, we already talked about this. We've talked about this. Reevaluate, consider multiple sources of data. I think my biggest piece too is I think every parent nowadays thinks that the IEP, or even a 504 for that matter, is some type of panacea, that it's just going to solve all their problems and remove any barriers from their kid being successful. But we know that IEPs are essentially designed to ensure that the child has access to general education. And I think on the front end, I say all that to say, we need to ensure that children meet criteria, they have an adverse educational impact, thusly requiring specially designed instruction, before we say that they're eligible. We're not giving these plans away like candy. It's not Oprah's Christmas party where everybody gets an IEP. Okay? And certainly Section 504 plans are not the consolation prize that we give out if they don't qualify. Okay, let's look at this other case. 13-year-old student identified as having a specific learning disability was exited from special education and related services based on a benchmark assessment that indicated she no longer demonstrated a severe discrepancy. Now, many of you may or may not know, so some states for SLD, instead of using RTI like we do, we used to use the discrepancy model, they look at their cognitive performance and their achievement performance. If the gap is great enough, they qualify. So they're saying a benchmark assessment, so let's say like Ames-Webb, they gave Ames-Webb, and it came back in the average range. Now there wasn't as big of a gap between her cognitive score and that achievement test. How do you think this went? We cannot use one assessment to drive any decision, ever. IDA reads that you must not use a single sole criterion to drive decisions, whether eligibility, services, any of that. It must be multiple sources of data. As you see here, even the appearance of doing so leads to litigation and you will not prevail. This applies to students with significant cognitive disabilities. Are you using one cognitive assessment to drive everything? That's a problem, okay? Courts further determined that the previous evaluation data and the observations which the district claimed they used indicated the student continued to have difficulties in reading and math, which could have sparked the need for further assessments. One benchmark assessment does not and should not drive those decisions. How many of you have had students that just Christmas tree that assessment down and they're like, oh, you passed. How did you do that? I've had kids that, I've had students with significant cognitive disabilities that would perform in the low average range on a cognitive assessment because they did really well at rote skills or working through our processing speed task really quickly. It doesn't mean that all of their skills are high enough to be able to, one, work on grade level standards without the modification, but certainly it's one piece of the puzzle. It should not be the puzzle. It's one of my big stink about RTI with specific learning disability evaluation is we just lay on that hill of progress monitoring data. Progress monitoring data is a tool. It is not an evaluation to determine eligibility, okay? It is one piece of the puzzle. How many of you have ever had an independent educational evaluation requested by a parent? One. You are lucky. Wherever districts you're coming from, holy moly, these have shot through the roof. So we know that every evaluation that we do, parents are entitled to an independent educational evaluation at no cost to them. So if I evaluate a kid for autism and the parent disagrees with my eval for whatever reason, she doesn't even have to give me a reason. She can go and seek an outside psychologist to evaluate the kid at district expense, at public expense, every single time I evaluate. That includes FBA's VIPs, by the way. Okay? So, what are our obligations? First, if they get an IE, you have two decisions as a district. You can fund it, pay for it, or you can fight it. I will say this past school year, I was so proud. I think we had 5 of these happen. And don't go back and tell your boss that big tall lady told you to do this, okay? Because, well, you probably can, because they probably already know that I would say this, especially our special education directors. If you fight it, you're filing due process against the parent. And you're arguing that your evaluation was sufficiently comprehensive to identify the kid and provide FAPE, okay? We have a lot of advocates and parents that they'll file for one of these just because they're mad at you and they want you to spend 10 grand on an outside eval. So we've had about 5 districts this past school year who have filed due process against the parent. 3 of them, the parents dropped their suit, their claim, before it even went to court because they said, oh, I need an attorney? Oh, I'm not doing that. The other 2 went to a due process. The LEAs prevailed. The administrative law judges said, yes, you did a sufficient comprehensive evaluation. They are not entitled to an IE. And here's why I love that. One, you're probably saying, April, carry the 2, divide by 17, whatever. That's expensive for a district to go to a due process and spend money on legal fees, absolutely. But these 2 parents, you know how parents talk, don't they? Do you think these other parents now are going to be getting in the business of hiring attorneys to ask for IEs if they're going to fail? Probably not. We needed 1 district to set a precedent, and now we have 5, okay? So if you get an IE request and you think it's frivolous, you can't just deny it. You only have 2 choices, fund it or fight it. That's your only option. I have an email from a district this morning who said, April, I told the parent that I would reevaluate and add this area. So she evaluated and she found the student eligible under SLD and LI, okay? And the parent said, no, I wanted an OHI evaluation too, or whatever. She wanted another category considered. And then she said, well, I'm going to have an IE look into that area. And the district said, no, we'll do it. Can you do that? As soon as they ask for an IE, the only 2 options you have, fund it or fight it, okay? And if you have any questions as that ever comes up, reach out to me, okay? The only thing you are bound to do when you get an IE is what? Consider it. A lot of parents think, well, the LEA is paying for this really expensive eval. Guess what? They have to do everything that they say. They have to make them eligible in these categories. They have to do all the services and recommendations. You don't have to do a darn thing with any of it. You're going to look at it. We've considered it. We're going to document we've considered it in a prior written notice, and then you can slide that IE right back over. Now, I say all that, but if there's good information in there, do we want to actually implement? Sure, you can implement it. If that's something you want to do, you can take that data and say, yeah, we're going to make them eligible in this category, but you're not required to do any of that. You're only required to consider it, okay? All right. I'm almost to the end. Eligibility category, I've already said this. Eligibility category serves as a gatekeeper. Remember, you're either eligible or you're not. Remember, it doesn't prescribe any type of services, amount of services. Where districts err is where we see every single kid who gets the same exact thing. That is contrary to how IDA reads, and we need to ensure that we're individualizing all those decisions to the greatest extent possible, okay? And when we think about specially designed instruction is special education, right? Does anybody know the definition? It means that you're adapting the content, methodology, or delivery of instructions for students with disabilities in order to give access to general education. It's all about access, folks. We want our students with disabilities, and I'm assuming that many of you probably have this, We have so many pull-out models for students with disabilities. My general education teachers, do most of your students with disabilities, do they leave the room to get instruction and then they come back when they're done? Or do they receive it in your classroom? A little bit of both? I love that. It sounds individualized. But when we have students leave our classrooms, we're missing everything else that core content teacher just taught. What can we do to give access and support them with that specially designed instruction in that general education setting? Okay. This is out of a case out of Wisconsin. I can pick in Wisconsin because that's where I'm from. Concerns itself not with labels, but with whether a student is receiving FAPE. That is the most important process here. And if you know a child is receiving FAPE, they're making progress. They're not making progress. If you're in the airport, if you see something, say something. If you know a kid's not making progress, do something about it. One of our biggest, I'm going to say this too before I end. One of our, I'm going to just get over to my email here. Julie Lane is my colleague, but she lives way far away, so I didn't ask her to come in this morning. One of the biggest due processes that happened across the state this year, you could read all the due processes folks, and you could read the administrative complaints. Go to TDOE website, look under legal services, you can find them all. All of the due processes are redacted, obviously you can't see names, and the administrative complaints are whittled down to what the claim was and then what the corrective action was. But this was a due process, you can see it, it was out of Knox County. Anybody from Knox County? Okay, I'm gonna pick on Knox County for a second. The child has a primary disability of autism and a secondary disability of intellectual disability. He was placed in a behavioral, self-contained classroom. Over the course of one school year, he was restrained 157 times. Okay? How many of you as special education teachers would be like, we should do something different? They had an FBA, BIP. It obviously wasn't working, folks. Okay? For me, it was just a checkbox. Okay? We did an FBA BIP, but we're still putting our hands on this kid 157 times. That's almost once a day. So at the end of that school year, they moved for a change of placement to a special day school because they said this placement isn't working. Parent filed due process. How do you think that went? We cannot just change placement before we have exhausted all of our supplementary aids and services as it reads in IDA. They did not attempt to do any type of work with the BCBA or an RBT in their school district. Nothing. They were just going to move this child to a more restrictive placement. As you can read in that due process, this district is now on the hook. I think this kid was 8 or 9. In perpetuity till he graduates, either walks across the stage with a regular diploma or ages out at 22. They're providing a full-time, full-day BCBA RBT. Do you know how much that cost? Over $1 million a year because they did not reach out, ask for support, not only from us, okay, but they were restraining this kid over and over again, and they didn't change what they were doing. If you see something, say something. If something's not going right, I would be reaching out to somebody who made more money than you and putting it in writing. This is my email address. Please reach out. Again, I oversee all things around evaluation, eligibility, behavior, restraint and isolation is also under my purview, mental health. Please reach out. We're here to support you and serve you. I hope you have a wonderful school year. Thank you. What questions do you have? Yes, I have like 3 minutes left. What questions do you have? Yes. Oh, I'm sorry, you're just scratching. It's okay. You got me excited.
So listen, y'all, this is your opportunity. Tennessee Department of Ed is standing right here. So please, and I'll bring the mic to you for recording purposes. So.
I teach a contained classroom in middle school. And a lot of my students that come to me still have the developmentally delayed notations. And we fight with the parents and even our psychologists to change it because they say it's not that big of a deal, even though it says we're required to change it. So how do we, because I mean, there's only so much I can do.
Yeah. So is it the parent that's fighting you?
Both. I had a parent this year, and it went round and round and round because they didn't want ID on their 15-year-old's IEP, but it should be there. And then we've also had issues with, the school psychologist saying, oh, it's okay, it'll be fine.
And so you're saying that they would want to keep them under the DD label?
Yes.
Well, let me say this. Our system won't let them do that. So the few small perks of TN Pulse is that if they actually are over the age of 10, it won't let you finalize that eligibility under DD. It'll give you an error code. But what I will say overall, I always like to talk about what is our purpose of school? Our purpose of school is to hopefully ensure that they are leaving at some point prepared for wherever they're going, wherever that is. And in order for us to do that, appropriate eligibility is vital, because not only that, but it opens certain doors. I was just talking to a colleague about functional delay. Do you guys have some kids who are functional delay? It looks like it's ID, but they don't have the same adaptive concerns. It's a problem for me because they leave, they're not entitled to Social Security, they're not entitled to like VR, any type of vocational resources. They probably wouldn't have gained entrance to any type of post-secondary program for student with developmental delays because it doesn't say that they have one, right? And so ID is important. If that's the most important category, they're limiting themselves long term. I've had parents who said, I would rather have OHI for ID. I'm like, no. And we have some memos that would address that. The easiest thing for you to do is if you would like to reach out to me, I'm happy to chat with that parent because one, we're not picking and choosing the more palatable eligibility category. We have a lot of parents that say, I'll take this eligibility category, but I won't take this one. We propose what's most appropriate. If parents disagree, what can they do? They can file due process, okay? We propose that provision of FAPE. And FAPE, again, is not a buffet, okay? What other questions do you have? Good question. Please reach out to me about that.
Questions? This is your opportunity. And remember, often the question you ask is something that someone else wants to know as well.
I will say, I know that Dr. Clark mentioned there's not a fall SPED conference. I hope you already, did anybody attend our Access conference last year in Chattanooga? One person. We're doing that again. It's free. It's the, Candace, what, is it the first week of September? You guys are awesome. 1st through the 3rd, it's in Chattanooga again, but the conference itself is free. But obviously a lot of TDOE people will be presenting, but also we had people that submitted their own proposals. And our legal team does a bunch of sessions as well. I know for me, I'm doing a ton around threat assessment, manifestation determination reviews, restraint and isolation. Those 3 areas right there are our top due processes in the state. And if you've never attended any of those, please come or reach out to me. I'm always happy to come out to your district as well. So I have just been on the road this past week at districts presenting all of these topics. I was in Hamilton County this past week doing threat assessment and MDR with all of their principals. So please reach out. That's why we're here. Any final comments, questions? If not, I'm gonna let you guys take a break and get some muffins.
So, Dr. Ebinger, many thanks for your many times that you've been here.
Oh, you're very
and
welcome.
y'all, this was jam-packed with some good stuff.